Sir, don't make speeches, sir. Keep it, put it on record. Apana kagaz nahi file karo to memo. Yes. Yes, please. Next.
Item 2.
Item 2. We have issued letter, no instruction has been received. Counter is necessary.
After 12 years.
In 22/12/2014, notice was issued.
Sita Asuna. ठीक है जी. I'll pass some order.
Yes, sir.
Yes, next.
Item 3.
Yes. Call. Kindly call.
Item 4. Item 5. Item 6.
Alright,
7.
Take your own. Let us complete this. Item 1 after order document.
Right.
Your name, sir, Mr. Maheshwar Mahanti.
I am on behalf of Maheshwar Mahanti.
I'm not sir.
Maheshwar Mahanti. I am Nirakar Behera.
So Nirakara Behera on behalf of Mr. Maheshwar Mahanti for the petitioner. Opposite party none. The application was presented before this court on 25/1/2012. On 24/2/2012, notices were issued by the coordinate bench. Thereafter, the matter has not been prosecuted by the petitioner. Today, when the matter is taken up, none appears for the opposite party, though the learned counsel is on record. The learned counsel for the learned counsel, no, it is submitted on behalf of the learned counsel for the petitioner that they do not have any instruction in the matter. Stating the same, memo is filed. Memo is filed, which is on which shall be kept on record. Scan copy was updated. The memo states thus. Quote करते The petitioner husband in the marriage by filing the petition has challenged the order dated 3/12/2011. Passed in IA number 52 of 2010, arising out of CP number 333/2010. The said IA was filed in the CP then pending. The said IA was filed in the CP then pending before the learned judge, Family Court, Balasore, under Section 24 of the Hindu Marriage Act, seeking maintenance pendente light. The CP was filed by the husband under Section 13 of the Hindu Marriage Act. Stop. In view of the memo filed and the facts of the case, the petition stands disposed of. Item 2, none appears for the petitioner when the matter is good. Item 2, लिखिए petitioner none, Mr. D.N. Lenka, AGA for the opposite party. 2 lecture none appears for the petitioner when the matter is called. The matter shall be listed in the week commencing. Shall be listed on 23/3/2026 under the same heading, indicating that the matter shall be finally disposed of. of the matter to retain its position in the list.
Item 3,
Petitioner none, opposite party none. Or দুইরে লিখিবেন কি? The writ petition is pending since 2014, being presented on 15/12/2014. Previous year लिखिल, that matter is pending. देखिए लिख देना है कौन? डेटा पाइबे नहीं कौन? कथोर था है, दिखाई था. Data present.
Ultimate in this.
ताको से डर. कौन लिखे? None. तापर लिखिल, the petitioner is pending since 2014, being presented on এটা কে কোড ইলেকশন 3 কোড 25/3/2015 the same order as in 2 है ना?
Item 4,
Pending since 2020, presented on 21/20 same order. Date गोटे दिन डेट रख दे so that effort support आपन का listing problem होबन ओटा सर्वर ब्लॉक रे आसी जाउची हो ହେଲା तापरे
item 5,
नहीं शुणନ୍ତୁ ଆପଣଙ୍କର ଏଇ ଯୋଉ ଯେତେକ ମ୍ୟାଟର ଯେମିତି ଉପରେ 5ଟା ରହିଛି ସେମିତି 23 ତାରିଖ ବି ଆସିବ ସବୁଡାକ 23 ହିଁ ଲେଖିବେ ତାହେଲେ ତାଙ୍କ ଲିଷ୍ଟିଂ ପ୍ରୋବ୍ଲେମ କଣ ହେଇଯିବ ଫେର 5 ରେ ବି ସେମ୍ ଅର୍ଡର Mr. Lenka, only except item 2, you are not there in any of the matters. So, sir, petitioner none, opposite party none. Mr. 2 रे Mr. Lenka is here.
item 7,
So, Somnasekhar Parda for the petitioner. Yes, Mr. Parda.
7, my lord, permitted to withdraw, my lord.
Kindly file memo.
My lord. No, only one indulgence, my lord. Only that the travel expenses of the wife when she is traveling from Bhubaneswar to Cuttack. That your lordship, if
Please appreciate Mr. Parda. Once you start doing that, it is not a conformity with law.
my lord,
Because I am not the conducting court.
my lord, liberty
The
of the
conducting court should, suppose you are agreed by any order.
my lord.
Are the doors of High Court are closed?
No, my lord. Only I was praying.
Sir, I find it really strange that petitions are we would have had. It's a general discussion. Executions are kept pending there, and you are lamenting here. Your one, how is pain is matter than showed. One line, one application, one line is enough to take care of everything. Suppose you are saying the judge is showing unnecessary indulgence. One reason is that when Mr. Lenka is seeking time, you indulge. When you are seeking time, Mr. Lenka, that is actually our practice, and I don't find any fault with that. But if you come to High Court for everything, this doesn't help you.
No.
But not in your case, definitely. You have been prudent enough to prosecute the main litigation.
No, only my lord, liberty for that. If I file a petition before the court will.
Any petition you have to file because the liberty is available to you.
Lordship is simply permitted to withdraw.
Yes. Kindly file the memo.
My lord,
The kitne number item? 7. Just 1 second. The Paradise matter. Take your seat. I'll dictate the order in 2 minutes. Hard learned counsel for the petitioner, he files memo of date which states thus. The petition was filed seeking transfer of CP number 542 of 2025 pending before the learned judge family court Cuttack to the court of the learned judge family court Bhubaneswar at Khurda. It is submitted by the learned counsel for the petitioner. Upon that, his instructions are stated in the memo that the petitioner doesn't want to prosecute this petition and shall prosecute the CP before the learned judge, family court, Cuttack. It is submitted that the petitioner shall file application in accordance with law before the learned trial court, seeking certain relief during pendency of the application. So, if any such application is filed, the same shall be dealt in its proper perspective in accordance with law. The petition stands disposed of.
Item 8,
Maybe.
Yes, please. You, Mr. Raut.
Yes, yes.
Mr. Ashok Kumar Raut for the petitioner. Yes. Yes.
My lord, both the petitioner and the opposite party, husband and wife, my lord.
Yes, please.
The present petition has been filed to transfer the civil proceeding before the learned court of family judge to senior civil judge Banki, my lord. The petitioner filed a criminal proceeding before the learned SDJM Banki, in which the
File call.
my lord, I have there.
Date of filing of suit, date of filing of criminal case.
My lord,
Sir, you have to come up these facts. So we have to
My
be
lord.
really quick there.
my lord.
Ipide kauna file ala.
My lord, criminal proceeding has been filed on 18/12/2023 before the learned SDJM Banki.
Yes. Cause of action?
Cause of action, my lord, marriage,
Place.
Yes.
Territorial jurisdiction.
my lord. The
My lord is the territorial jurisdiction.
my lord, the petitioner is staying at his
अरे आपनकर जो criminal case file कले,
My
two
lord.
section रे, two दफा
25 CRPC, my lord.
125. So that's not a criminal. That is a quasi criminal. That's a maintenance thing.
My lord.
So how does it help you in shifting the petition? आपनकर CP को तो केबे file ହେଲା?
CP, my lord, file 4/11/2025.
4/11/25. So show me a decision where it has been held by the High Court or the Supreme Court
My lord.
that if 125 CRPC has been filed in a particular place, then the cause of action will shift to that place. Everything will be filed in 125
And
CRPC.
convenience, my lord, convenience.
Convenience कोठी अछि?
And the wife is filing the 125 CRPC before the learned SDJM Banki, and the opposite party husband is requesting there.
125 अछि territorial jurisdiction टा कोथरे अछि? Two section.
My lord, 125 CRPC.
Kothi अछि the CRPC itself provides for the territorial jurisdiction for initiation of the matter under 125 in a section. Which section? That these things I should not assist you. You should educate me. 126. The provision is very clear. It can be at anywhere.
My lord.
Respectfully. So that doesn't help you. Have you checked the jurisdiction?
So far as jurisdiction is
So far, you have not read 126, sir. I answered
my
the
lord,
question. So kindly
the place of marriage. place of-
you have not checked, sir. Don't never guess, second guess anything. देखो 126 देखो. Read it aloud, so because I have lent you my book.
Where he or she's wife rejects, or where the last resided with his wife, or as the case may be, with the mother of the illegitimate child, that the procedure, my lord, 126.
So 126 doesn't help you
My lord.
because 125 is for the convenience of the wife.
My lord.
So that doesn't guide a court for transferring the CP. ଆପଣ CP ରେ କଣ ହେଇଛି ସେଟା ମତେ that you have to
That
address.
CP has
How
filed-
CP transferring the CP to Banki will be convenient.
My lord, the petitioner wife is residing at her parents' house at Banki.
Who has filed the CP?
The CP has been filed by the husband at Noyagad. Under section 9 of the restitution of 9 of the Hindu Marriage Act for restitution of conjugal rights. When the husband was contesting the case at the CRP proceeding at Banki, my lord, and interim maintenance was allowed, and thereafter, when the CRPC is pending and sub judice, and he is contesting there from Noyagad to Banki, filed this petition.
Transfer ରେ କଣ ହେଇଯିବ ଆପଣ ମେରିଟ ରେ କଣ ଆଡ୍ରେସ କରୁଛନ୍ତି?
I have mentioned that
ସବୁ କଥାରେ
there is one minor child of 4 years.
125 ର CP ର କଣ ରିଲେସନସିପ ମୁଁ ବୁଝିପାରୁନି ସେକ୍ସନ 9 ଆପଣ ଚାହୁଁଛନ୍ତି ଟ୍ରାନ୍ସଫର ହେଉ ସେ ଦ୍ୟାଟ ଯେ ମୁଁ ବାଙ୍କିରେ ରହୁଛି
My lord.
ସେକ୍ସନ 9 ତା ବାଙ୍କିକୁ ଆସୁ
My lord.
that is what you are saying.
My lord.
So before that you should not say anything 125 all these things you should not because that has no relevance. ଆପଣ ଯଦି ବର୍ତ୍ତମାନ ଆମେରିକାରେ ରହିବେ 125 କୋଉଠି ଫାଇଲ କରିବେ ଟେକ୍ନିକାଲି ଆମେରିକାରେ ଫାଇଲ କରିବେ
My lord.
can I put that that's the provision କଣ ଏଟା ଟ୍ରାନ୍ସଫର ହେବ ସେଠିକି
And my lord.
let us it is a hypothetical
Yes.
so you must say that the petitioner wife is before this court seeking transfer of the CP. Because you must understand that what you are submitting will be reflected in my order also. If I start reflecting these things, because 125 is filed in Banki, the CP should be filed in Banki. That it makes no sense for any judicial order. That please appreciate that. CP number एते, CP number dash. Code election सेटा है?
225 of 2025, my lord.
225 अपन page अच्छी.
No, my lord.
CP टा code election थी.
It has been mentioned in synopsis and also
Affidavit
I have also filed annexure, my lord, too.
अरे affidavit रे code election.
No, my lord.
हाँ?
First paragraph 1, my lord, I will mention.
एटा कितने नंबर पेज?
Page 2, my lord.
हाँ? 2. कौन CP number टा election दी paragraph 2 रे?
My lord.
कौन petition कौन पर हाथ रे गाड़ी चंदी ना कौन?
No, my lord.
कोड लिख ले पढ़िले sentence टा?
The petitioner has filed the aforesaid TRP application, transfer of 225 CP number 225 of 2025 pending in the Court of Learned Judge, Family Court, Noyagarh, to the Court of the Learned Civil Judge, Senior Division, Banki, my lord.
2 of 2026.
My lord, 225.
Para 1, para 2, no, but I was holding some other page actually. This digital has this limitation. Suddenly you cannot get the page by, you don't realize what is the physical page. कौन लिख ले?
Sir, also.
225 of 2025. Pending before the Court of Learned Judge, Family Court, Noyagarh. You take your seat, I'll dictate the order. I'll take some time. Family Court, Noyagarh, to the Court of Learned Civil Judge, Senior Division, Banki. The CP has been filed, the CP has been filed by the husband in the marriage. Under Section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. সেটা কোড লিখলে এটা লিখতে কপি ফাইল করছো লিখুন
Page 10, annexure.
Section 9 of the Hindu Marriage Act 1955 seeking
Or
restitution of
16.
conjugal rights. Stop. It is submitted that after solemnization of marriage on 26/11/2021, the petitioner, though, was staying in her matrimonial home. After the marriage has ran into rough weather, she stays with her parents at Bodheshwara Banki. Para. Issue notice along with this order. Requisites for issuance of notice by speed post registration and proof of delivery shall be filed within how much time? 5 working days?
3 days.
Within 3 working days. The list after SR, liberty to mention. IA number 2 of 2026, issue notice as above. What is the next date in the CP?
CP, I don't know.
Then who will
No
do, sir?
information, sir. I have already appeared there.
Sir, how do you, sir? Then what the court will do, sir? Court should not assist you like this. You should get these basic facts at your fingertips.
Sir. That was
It is
November.
on being asked, the learned counsel for the petitioner submits that he doesn't have instruction regarding the next date of posting, listing of next date of posting of the CP number 225 of 2025. Notice we issued in the petition as well as the IA fixing returnable date. Ajela कितने 18. Fixing returnable date 11 March 2026. The Learned Judge Family Court, Noyagada, shall adjourn the CP 225 of 2025 pending before him to a date beyond 30/3/2026 as would be suitable to the court. As would be suitable to the said court. Upon a prayer being made on that behalf, list in the week commencing 4 of March 2026. Yes.
Item 9,
May I please, Your Lordship? The transfer application file, Your Lordship, to transfer the guardian miss case 11/2025 pending for the law and discharge Denkana to the law and discharge Jaspur, Your Lordship. The present petitioners are the maternal grandparents of the child, Your Lordship.
So what is the Mr. Bora?
My
What is the jurisprudence on this? In husband and wife, husband's convenience, or sorry, wife's convenience.
My Lords.
Then in a guardianship petition, whose convenience? There is no case law on this. Because by transferring and all these things, the whole trial is frustrated. The pendency increases. The objective of that this section 24 of CPC is not for a frustrating trial. That is, it has not evolved like that. At least now, lawyers like you have realized that transferring from Bhubaneswar to Cuttack to Bhubaneswar. I'm just saying, give
Yes.
an example. He's not helping the business. Because, like yesterday's matter, somebody wants to transfer from Cuttack to Bhubaneswar. Bhubaneswar is overburdened. And the matter will be renumbered. That is my understanding. It becomes a 2026 matter, pending since 24. It cannot be prioritized. That is another problem also. Suppose you expect the matter to be taken up, it has to come in the board for 26 matters,
Yes.
2026. So you obtain instruction.
But here,
Because the other aspect, suppose the parties are facing any difficulty for appearance, then after ICT, every court is having that. So with that observation of the court, difficulty to appear physically becomes redundant. You must understand that. If I accept in fact, you have not argued. I'm just discussing.
yes.
Suppose you take that plea even. So that plea is not also nowadays available. Then suppose the court, ICT, I find that it is now also a little bit overburdened. In the sense, both look interested. Many people are interested. So they will give a date. If not today, suppose you seek ICT, already the BC hall is, that BC facility is already
Fill up.
booked for
Yes.
3-4 cases. So maybe tomorrow or maybe 15 days after.
Yes. But
Because convenience of the parties cannot be a ground in a guardianship application unless it is between lady and the father and mother. That also, in fact, how far you can say that it is convenient for the lady, so it has to be at a particular place.
here,
Cause of action and other things for production
Yes.
of the child and other factors have to be there if at all the
Yes.
child is to be interviewed. And in case of a High Court case, you see, interstate or interdistrict disputes, cases are filed in High Court. We are seeking procuring presence of the child also
yes.
for having interview. So it is exactly not a ground that child cannot be also interviewed by the court. So you take instruction. I am simply adjourning it.
Here the matter, Lordship, the marriage took place on 12/5/19, and the OP husband tortured our daughter. Thereafter, she came to the petitioner's house parents and resided there. The child born there, and thereafter, due to illness, Lordship, she died. Mother died. After giving birth to the child, Lordship, after 2 months of the birth of the child, the mother died. The father never seen the face of the child, Lordship, son. And after the death of our daughter, we are taking care of the child, and he is residing with us, and now he has already been admitted in the St. Xavier school, and we are taking all such care of the child, Lordship. and the father now filed the application under the Guardian Act for custody of the child at Learning Discharge, Tenkana LRC. And in between, two affairs was lodged against the husband and other in-laws member. That is pending at
FIR for what?
one FIR by the our late daughter, so far torture and everything, and another by one of another daughter lordship, so far allegation of rape against the main accused, the brother of the husband. And entire family members are there in the accused lordship. Two cases is pending there in the jurisdiction of the Jashpur. And at the
That's your case. That spoils, completely spoils your case, dismantles your case. Unrelated criminal matters, how it will be brought into the guardians and what's petition. Sir, I mean, you must understand that maybe these are the facts. The facts has changed. Maybe what has happened, you do not know. But how this will help you in getting at the matter, because and the law is overwhelming in favor of the natural guardian.
Yes, that should be adjudicated.
Even I mean, murder accused has the right to have the custody. That is the law.
Yes, that is that will adjudicate.
Have you check those cases where it has happened like that? There are direct decisions of Supreme Court. Cited by one division bench of this court.
That will be,
because you see, because the problem is that the natural guardian has an overwhelming right as far as others are concerned. This emotional approach that the father has not seen the child, all this thing doesn't help, because that law has not evolved like that. Law is very clear.
the natural
Guardian has a right for a minor or a major child. Minor child, of course, not major child. Minor child for having the custody. And unfortunately, the first FIR, what you are saying, the person has passed away. So that has abated. Second FIR is by a relative against relative of the father. So that doesn't, it is neither here nor there.
So far the convenience is concerned.
Cases have absolutely no bearing or connection with this.
No, so far the convenience of the particularship for that
The person who seeks guardianship,
minors.
he has to file it within his jurisdiction of the jurisdictional court.
Yes.
Jurisdiction.
Yes, he has filed.
He stays in Dhankana and filed it in Dhankana. Why the person who are registering, who are having the custody of the child, they will say that it should be at our place. How can it be? You have to file a suit. Suppose somebody wants to file a suit, it has to be the place of residence, as per the CPC. It cannot be that convenience of the other side. Cannot be.
So we have to fight with the OPLRC.
You must understand that you are not the natural guardian.
But we have to take care of the child.
Taking care of, you must understand, Mr. Bora, being emotive doesn't make a legally nuanced submission. There is no such case law that taking care, enhances the rights of a particular maternal or paternal grandparents for having custody of the child.
Yes,
Custody is very well defined. Law is very well defined.
Yes, Lord. That will be decided in the suit LRC.
So it can't be transferred. Today I am not adjourning, I am not passing order. It can't be transferred. Because then you have to check up law. But still I give you opportunity that if you have any guardianship that the person who seeks, he files a petition. It is his case, he is the dominus litis. How the court will say that no, you don't go there, go to Jashpur. It will be convenient to the other side who are now having the custody.
The child.
Rather for contact rights or visitation rights, it will be difficult for him to come to Jashpur. You must understand that way also. What is the interim prayer in a typical guardianship petition? Visitation and contact rights. So, this doesn't make sense. Absolutely no legal basis apart from emotional appeal that we have been taking care of the child. This has happened. This is not the first time. In fact, many of the guardianship applications arise out of these kind of facts. Grandparents objecting. In fact, in some cases, the death of the mother also, the court has granted because he is the natural guardian. Which law prohibits the accused from not having custody of the child?
That is.
And if he's a convict, then the law intervenes to, dissect the, contact and vegetation. That's another thing. After he serves his sentence, he will come back to the society. Can he be deprived of the custody? Can it be a ground that since he's in custody for last 14 years for some offense, or like he was a life imprisonment, now he has come in parole, so he can't have custody of the child. That kind of is not there. Even to other country also, Supreme Court has granted. The specific plea is that the father is facing charges of murder in the other country, foreign country. Supreme Court has granted. And you should, the approach is what will happen in trial, it is up to the court. And
Yes.
The parties to adduce evidence.
My lord.
I'll take it up on another day. If you just check up,
Yes.
so that will help us, both of us. At
Right.
least if you help me.
My lord.
Check up if any law has evolved, because there is nothing. That division bench judgment I'm referring, that was rendered by me actually.
Right.
With sitting with Honorable Justice Vishwanath Ratha, he agreed. So there it has been discussed that, but there the facts are different, little bit different.
My
So
lord.
my point is that transfer will not, that is appeal.
Yes.
Maybe you will be succeeding in your resisting the transfer of custody. Handing over the custody, you will succeed in Dhekkanal also. There is no difficulty. But transfer will, now this is a
113.
classic case where transfer will stall the proceeding.
The 113 kilometers distance from the court of the land district Jaspur to district
You have to, sir, you have to have
we are the
this aspect is not available that in family courts matter, ambiguous
We-
security be appointed. Wherever, sir, you have to have trusted lawyer. This approach of not engaging lawyers, local lawyers cannot be.
the issue may come the child travel with us.
Then you see the traveling of child cannot be made a ground. Because you should not carry then you are not taking care of the child. Why should you carry the child to the court? If at all you are required for
The
evidence.
proceeding a lot.
You can make a prayer for appearing to at remote location, because those things are there. The Mr. Sushanta Kumar Barala for the petitioner, opposite party blank. The petition has been filed seeking transfer of the guardian miss case number 11 of 2025. Pending before the Lord District Judge Dhekkanal. The application has been filed by the father of the minor child, wherein the present petitioners are the respondents. Stop. The application has been filed under the application before the Lord Judge family. You take your seat. I'll adjourn it and observe these record these submissions and I'll adjourn it. All right. Has been filed under section 6 and section 8 of section 8 of the Guardianship and Wards Act 1890, read with section 6 of Hindu Minority and Guardianship Act of 1956 by the opposite party father of the child. Seeking custody of the child, who is now aged about
6 years.
6 years, 5 years. 20 ହେଲେ 20 5 25 5 years. Aged about 5 years. Para. The learned counsel for the petitioner was heard at length. Stop. He has adjournment to address further. List. Kebe Mr. Gora?
A week after last.
What a week after Cordianto? List in the matters shall be listed for fresh admission in the week commencing. Do it in.
Obliged.
What do it in the Tinita working day? One activity. Tata be working a cheap. Adjusted holiday. Day before. Yes, next please.
Item 10,
May I please, Your
Miss
Lordship?
Sahoo.
Yes, Your Lordship. Lordship,
Mr.
may I
Sahoo
do
for
one
the
thing, Your Lordship?
petitioner. It is submitted by the Lord Council, Mr. Prem Kumar Manti AC for the state. It is submitted by Ms. Sahu that it was called
Lordship, registration of sale deed matter, Your Lordship.
the matter pertains to the non-registration of sale deed under the Registration Act,
Yes, Your Lordship.
which is not in the determination of this court. Stop. The matter shall be placed before registry for to do the needful for listing of the matter
Yes, sir.
before the assignment. Yes.
It date may be fixed, Your Lordship.
Date I cannot direct. I do not also.
Obliged, Your Lordship.
It may require administrative order of the Honorable Chief Justice. I don't know, but maybe registry will do them themselves.
Yes, Your Lordship.
Yes,
Obliged.
11,
My lords. Unless there is a noting in item 11 that
26 item delivered. आज कितना तारीख है लगी?
18.
ଆପଣ ଏମିତି ବହୁତ prompt ହେଇଗଲେଣି ତ? ଆପଣ same day ଦେଇ ଦଉଛନ୍ତି notice? Really? Very good. ମାନେ କାଲି ଏଇଟା ଆପଣ ଦେଇ ଦଉଛନ୍ତି? ସିଏ ବି କଣ 10ଟା ଯାଏଁ ବସିଲେଣି? ତା ଭୁଲ ଭାଲ ଡେଟ୍ ହେଇଯାଇଛି। Flat 3 and 4.
Sir, flag B ଅଛି sir.
The postal tracking report, Mr. Ankan Panda.
Yes, ma'am.
So Ankan Panda for the petitioner. The postal tracking report obtained from the Department of Posts, Government of India, has been placed on record by the registry, which indicates code 4. Right? ଏଠୁ କଣ ହେଲା ନା ଏଇଟା ତ ସେମିତି କିଛି ଲେଖା ହେଇନି 17/3/26
Objection में अच्छी next को 20.
That the item has been delivered on Surya 12/25. So then what, sir? Then what? ଆପଣଙ୍କ ଏରିଆ କେତେ ଅଛି?
Sir, area to convert it.
BC 630 31 ମାସରେ ଆପଣଙ୍କର ଏରିଆ
ଆଜ୍ଞା
କେତେ ଟଙ୍କା ଅଛି?
31.
$15,000
Yes, ma'am.
ହଁ କଣ ଦେବେନି?
So ମୁଁ explain ଘରେ ବି ମୁଁ ରହୁନି. Even
ଆପଣଙ୍କର ସାଲାରୀ ଅଛି ନା ଆପଣ ଘର ଦରକାର ନାହିଁ ଘର ଦେଲେ ଘର ଆକ୍ସନ
EMI ବି ପେ କରୁଛି sir ମୁଁ ଏବେ recent ଗୋଟେ accident ରୁ ବି recover କରୁଛି.
ସାଲାରୀଟା ପାଇଁ ଘର ଦେବେ ନା କଣ? ଧରନ୍ତୁ ଆପଣ ଫ୍ରାକ୍ଚର ହେଲା ସେ କଣ ଆପଣ ସିଜ୍ କରୁଛନ୍ତି? ଆପଣଙ୍କ ସାଲାରୀ ପାଉଛନ୍ତି ଦେବେ ନା ଦେବେନି?
So କିଛି
15,000 ଟଙ୍କା ମାସକୁ
କିଛିଟା deduct ହଉଛି.
ହଉଛି ତ ଦେଲେ ଅବସ୍ଥା କେହି ହଉଛନ୍ତି
डिडक्शन टिके 15,000 सर मोर मेडिकल एक्सपेंसेस अछि मु से घरे भी रोनी
କିଛି କରିନି
वो बाहरे रेंट रे रहउछ
ପଢିଛନ୍ତି
मेंटेनेंस
ହୋଟେଲ 5 star ହୋଟେଲରେ ରହିବେ ପର ଏକ୍ସପେନ୍ସେସ୍ 20,000 ଟଙ୍କା obviously you have to pay. So can that be a relevant consideration in for the not awarding maintenance because he stays in a 5 star hotel, his per expenditure is 15,000, he cannot pay. It's a very good logic because it is you are a master of your own thoughts and liberty. Court cannot curtail you from staying in a 5 star hotel and spending 15,000 or maybe 50,000. In a hotel, suppose any hotel, 5 star is too big amount. Those are irrelevant considerations. Administrative law को बही पढ़छो
किछरा डिडक्ट हो 15,000 रु एपड भी
अपन 15,000 जदि असुविधा होची अपन केतना खर्च करछोने मासुकु how much you are spending per month
सर EMI 17,000 above for the new house sir.
new house अपन ऑप्शन नहीं जाऊ अपन को new house 17,000 के 71,000 देबे बोली the two souls will not be paid anything by the court. Which case law has said that?
So I will pay my lawyer. At least some reduction with
Sir, you are not getting or you are pretending not to understand. How much you are spending apart from EMI? EMI is a irrelevant consideration. That is how I asked you that whether which case law, which administrative law book you have read, so that you will understand what I am saying. It's a test in a administrative testing administrative action. The same parameter can be applied to a judicial pronouncement also. Can the court take into account that you are staying in a hotel or your rented premises for that 10,000? What is your job? What you are? How much you are earning? कौन करछुन दे आपण?
so teacher अछि teacher अछि PET teacher.
PET.
Yes my lord.
कोन को स्कूल केते रेंज रे अछंती? कॉलेज रे स्कूल रे मैडम.
School rounds
कौन आपण सैलरी काहे केते आपण पाउछन?
35 to 40.
हैं?
35 to 40.
कौन आपण को प्राइमरी ना को स्टेज जगह कोड लिखछन से कोड डब्ल्यूएस रे कोड लिखले. Sir, this cannot be a cover up operation. You must understand. The proceeding before the court is you are discovering truth. It can't be covered up. Which part the court has dealt with your salary and which part of which paragraph?
Page 14 my lords.
So which was the exhibit? But these things are you have to prepare, not the court.
Yes.
Be assured that I am reading with you. Because you may think that because I am going somewhere else. I am not going. I am completely with you. Which was the exhibit exhibited before the trial court? Exhibit 4. So what is the salary? 51.354. You take a rent and stay there for 20,000. 17,000 you EMI. So you suppose that amount is given to the lady and you stay with that amount of 15,000. What is the difficulty? I can direct it. You will accept 15,000. Yes. Yes, Mr. Panda. You must understand that you are making my order vulnerable. If I start writing these orders, he stays in a rented house and spends EMI 17,000 for purchasing a new house. For himself, he spends rest of the money. So the lady and the child will not get 15,000 per month. These questions you have to ask. You are an officer. You are at a much higher level. You are not having protecting the agenda of the party not to pay anything. It's a provision of law. Out of the area 30 months, how much you have paid? 31 months.
CRL maintenance proceeding is going on my lords. The coming date is
Interim maintenance date is there, sir. Otherwise, the court cannot
Yes.
think about it that 31 months, like out of the year, I have plugged it. So, what do you want now?
it will be so on next day we are filing an objection in the lower court below my lords
What objection you will file?
about the salary statement they have provided.
Who has provided?
by the opposite party.
So do whatever you want. You do whatever you want. Which person will survive in 5,000 per month? Court has granted you 5,000. There is every reason that CRC will file for enhancement. Awaiting appearance of the opposite party, list in the week commencing. Do it in. Is there any interim order?
No, it's
Then
Lord would be willed not to pass any order because
why? Why? Why this indulgence, interference in court process? That too by a superior court. Why this court passed orders which are not in conformity with law? Absurd orders. You have to. That is how we have been discussing, spending time. That what you want from this court. Absurd and illegal orders. Can it be? Because this court has power, it will pass orders. Does not appeal to common sense, doesn't appeal to law. The lower court shall proceed in the matter in accordance with law. The learned judge family court, the court pending ach.
so Bhavani Patna family
Learned judge family court Bhavani Patna shall proceed in the matter in the pending proceeding in accordance with law. In fact, this is the reason actually it has not benefited you. Frustrating the proceeding there, you should have contested there. You may get an order. You challenge that order. At least that would help the person to do something, decide something. This, the whole branch, this transfer petitions, RPFM, all these things is entirely not helping the cause. Suppose you want to contest the matters that you are not going to pay that 15,000. The best, in your best interest, there should be a final adjudication based on merits. And I asked you, did not answer that. 125 itself, there is a provision. What you were saying before, this court doesn't have that power, but the court which granted 125 has that power. Have you checked that? Yes, next. List in the week commencing? Do it in. Do it in में कौन है it are for orders. 16 thing. Yes.
12,
Transfer to the South. Notice issued. An honorable court directed to serve the notice on OP
They
number.
have acted, I think.
I know, OP number 9. After for OP number.
All other OPs are now on record.
To
228
for the
your
petitioner. Say that he has not appeared there before Puri also, Mr. Misra.
No, that was not received. Court, Honorable High Court directed to serve the notice through the trial court. Trial court both, they have not reported to this court.
Kindly take that soft copy. Letter number 5-1-26. Letter dated 5-1-26.
So director, again I shall take step to him to.
Just body deal so that you get the context. Scroll ନ କରି ସେଟା touch କରନ୍ତୁ. Go to the bookmark. Bookmark ରେ ତଳେ ଦେଖନ୍ତୁ ଗୋଟେ letter ଅଛି. Letter number 24 dated 5-1-26 flag F.
Well, I have gone through that.
ମୁଁ ଆଉ ଥରେ ନୋଟିସ୍ ନଉଛି ଆଉ
ସେ ଭୁବନେଶ୍ୱର ଯାଇଛି ତ ସେଇ ଜିନିଷଟା ମତେ ଲାଗିଲା ଯେ ମୁଁ ଠିକ ମନେ ଅଛି ଆପଣ ଯୋଉ କହିଲେ I thought that କି maybe I have forgotten but I remember correctly ସେ appear କରିନି ସେଠି so without so that is how at times I ask
କ୍ଲିୟରାନ୍ସ ନଥିଲେ କୋର୍ଟ କଣ କରିବ?
କଣ କରିବେ so that we should have checked or the learned instructing counsel should have told you that he has appeared or not appeared so usually the question is where she is appearing or he is appearing that's the first question to be
Ultimately,
say ଠିକ ଅଛି ଆମେ let us wait from Bhubaneswar also
ମୁଁ ଆଉ ଥରେ ବି ନଉଛି in the meantime ତାଙ୍କୁ ଡାଇରେକ୍ଟଲି ନଉଛି
ସେ ଦିଟା ଆଡ୍ରେସ ଯୋଉ ଦେଇଛନ୍ତି ସେଥିରେ ସେ ହଉନି ବର୍ତ୍ତମାନ ପୁରୀ ଆପଣଙ୍କର ପ୍ରଚେଷ୍ଟା ବଳରେ ବର୍ତ୍ତମାନ
କଟକ କୋର୍ଟରେ ବି ଗୋଟେ ସୁଟ୍ ପେଣ୍ଡିଂ ଅଛି ଆମ ଭିତରେ
ତ ସେ କନେକ୍ଟେଡ ନହେଲେ ହବନି
ସେଟା କନେକ୍ଟେଡ ନା ଟ୍ରାନ୍ସଫର
connected with this particular petition
yes this is connected
ସେଟା does it arise of that petition from Kotak
ଏଇଥିରେ ଏଇଟା ଟ୍ରାନ୍ସଫର ପାଇଁ ସିଭିଲ ସୁଟ୍ ଦିଟା ଗ୍ରାଉଣ୍ଡ earlier
I am not saying that sir
earlier
sir does this petition emanate from the Kotak thing then why it went to Puri କଟକରେ ଯୋଉ କେସ୍ ପେଣ୍ଡିଂ ଅଛି କଟକ କେସ୍ ରୁ ଗୋଟେ କେସ୍ ହାଇକୋର୍ଟ ରେ ଫାଇଲ ହେଲା
କହୁଛି ଆମେ କହୁଛୁ ପୁରୀରୁ କଟକ ଆସୁ
ସେ ଭୁବନେଶ୍ୱର ଦେଇଛନ୍ତି ଭୁବନେଶ୍ୱର ପଠେଇଦେଲେ ତାଙ୍କ ଆଡ୍ରେସ ରେ ଯୋଉ ଆଡ୍ରେସ ଦିଟା ପୁରୀ କୋର୍ଟ ରେ ଫାଇଲ ହେଇଛି ଆଡ୍ରେସ ଷ୍ଟେଟମେଣ୍ଟ ରେ ଭୁବନେଶ୍ୱର ତ ଭୁବନେଶ୍ୱର ପଠେଇ ଦେଇଛନ୍ତି
ମୋର ବି ତ ଭୁବନେଶ୍ୱର ଆଡ୍ରେସ ଶହୀଦନଗର ଖୋର୍ଦ୍ଧା
କରେକ୍ଟ ତ ସେଟା ଅଲରେଡି ପଳେଇଛି ଆପଣଙ୍କର ସେଇଟା ଦ୍ୟାଟ ହାଜ ବିନ୍ ଡନ୍ ଏଟା ଲାଷ୍ଟ ଅର୍ଡର କଣ ଥିଲା So that Mr. for the petitioner Miss R. Singh.
awaiting
Mr.
sufficient notice on the other
R. Singh for the opposite parties 8 to 9, along with Mr. Rat Singh for the
9.
only 9.
Only 9.
Only 9.
ଅନ୍ୟମାନଙ୍କ ଉପରେ ଜାରି ହେଇଯାଇଛି ନୋଟିଂ ଆସିଛି ଆପଣଙ୍କର ରେଜିଷ୍ଟ୍ରି ଦେଇଛି
The office may request the judge in charge Nijar Bhubaneswar as well as the learned judge Civil Judge Senior Division Puri with reference to the letter number 24 dated 5/1/2026 forwarded by the learned Civil Judge Senior Division Puri to this court regarding issuance and sufficiency of notice to ki kitna number OP?
ଏକ
OP number 1. Awaiting response from both the courts, the matter stands adjourned to be listed on 23 na 23 ke 23 in the week commencing 23
ଆର ଗୁଡାକ ସଫିସିଏଣ୍ଟ ବୋଲି ଆପଣ
ଆସୁ ଦେଖିବ I hope ki some lawyers will be engaged by that. The registry shall also verify shall also verify if any learned counsel has entered appearance for the other opposite parties on whom the notice has been sufficient.
ଇଣ୍ଟ୍ରି ମର୍ଡର ଥିଲା
Interim order as
ଆର୍ଜନମେଣ୍ଟ ନେବି ସେଠି ବୋଲି
ସେ order ଟା 15/1 पारा 5 जोटा नहीं चलो रिपीट करते पारा 5 in order number 4 just the last A3 भी last paragraph हो awaiting sufficiency खाली add कर दियो तो awaiting sufficiency and appearance of the opposite parties sufficiency of notice and that's it. Yes, no, please.
Item 13.
Item 13 is page lordship.
13 Mr. you are there.
Yes, my lord. A. Mishra.
Adya Siddhi Mishra for the petitioner. Yes.
Why, sir? There's a delay of 24 days.
What is the amount due?
1,35,000 area from 2023 till the second judgment by the district first ADJ.
Yes.
2025, my lord. 26/9/2025.
This is a petition seeking 24 or 125?
Of challenging 125, I have come to this court of the first ADJ.
5 minutes जाके ऐसी I'll take a 5 minutes break. I'll come back to
Much
you are in a hurry or
No, my lord.
please.
Lordship. 2023, 26/3,
So
2020.
area, how much you have instructions to pay, you obtain that instruction.
I have already paid, as per my instruction, I have already paid 75,000 out of 1,35,000 for the 5,000 rupees per month.
No, what is the direction? Kindly check, then you will understand what is the area. You want challenging?
There was initially case where 5,000 rupees per month was granted by the JMFC Rural. After that was filed by the opposite party for enhancement
Yes.
to 25,000. So from 2023 till 2025, from the passing of that final order by the first ABJ, my lord, that amount is 1,35,000. So my instruction is I have already paid 75,000
So the initial direction was at the rate of
at the rate of 5,000 per month
from
2023, 10/2023, my lord.
5,000.
5,000 rupees.
It was enhanced on which date?
But 26/9/2025, my lord.
So please repeat again the 5,000 from
31/10/2023. 31/10/2023.
13/10.
31/10.
31/10.
31/10/23
23
ରୁ
ତାପରେ?
5,000 ଟଙ୍କା
ତାପରେ up to
ଅପ୍ ଟୁ 26/9/25 ରେ ତାଙ୍କର ଯୋଉ ଏନାଉନ୍ସମେଣ୍ଟ ଟା କରିଛନ୍ତି 25,000 ଟଙ୍କା ଯୋଉଟା ସେଟା ମୁଁ ଚ୍ୟାଲେଞ୍ଜ କରି ଏବେ କୋର୍ଟରେ ଆସିଛି।
ଆଚ୍ଛା ଇଏ କଣ କରୁଛନ୍ତି ଯିଏ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି what he does, what is the source of income?
My instruction is that he's working on IT company.
No, what was the material before the trial court? Because it's not a personal inquiry, it can't be either of you or me. So what was the material that was taken by the court into consideration to arrive at a conclusion? So that is important.
I also asked for the same the assessment liability ର ସେ petition ଯଦି କାଳେ ଦେଇଥିବେ କଣ ଦେଇଥିବେ but ମୋ ପାଖେ କିଛି instruction ନାହିଁ କି ସେ କି IT company ଖାଲି 2 ଲକ୍ଷ ଟଙ୍କା ବୋଲି ଲେଖା ହେଇଛି ବି averment ରେ court below ର order ରେ but ପଚାରିଥିଲି but
And he is also not interested if he is not assisting the counsel. The counsel is sincere and the person doesn't and the client doesn't assist the counsel. Then he is not also interested. He is not serious about the case. Then what argument you will, how you will assist me then? Now the question is that what, in fact, I can't, pass any order relying on any material.
ମୁଁ ତାଙ୍କ ସହିତ କହିଲି
ସେ 26/25 ରୁ ତାପରେ
24/25 ଅର୍ଡର ଟାକୁ ମୁଁ ଚ୍ୟାଲେଞ୍ଜ କରିଛି ଏଇଠି
କରେକ୍ଟ ସେଟା କେବେଠୁ with effect from କେତେ ହେଲା?
26
is application 48 ତ ଆପଣଙ୍କର 48 yes.
yes ma'am.
Improved order page 31.
Ma'am, 31. Oh.
So ଆପଣଙ୍କର 31/10/23 ରୁ ହିଁ ହଉଛି 25,000 ସେ କହିଛନ୍ତି
ଆଜ୍ଞା ଠିକ କହିଛନ୍ତି।
So 31/10/23 ରୁ ଯୋଉ 25,000 ବଢିଲା so that becomes 2 ବର୍ଷ ହେଇଗଲା 31/10/2025 ତା 3 ମାସ ତା ମାନେ 24 into
after that there was an execution case. Execution case I paid 75,000 as translation.
$6 ଲକ୍ଷ ଟଙ୍କା ଏରିଆ
ଆଜ୍ଞା
6 ଲକ୍ଷ ପ୍ଲସ୍ 50 6 ଲକ୍ଷ 50,000 ଟଙ୍କା ଏରିଆ
ମୋର ଇମ୍ପ୍ରୁଭ ଚ୍ୟାଲେଞ୍ଜ ସେଇଟା initially 1 lakh
but unless you secure that I am not interfering. The problem is that once I issue notice, if you have marked today that after the notice has been issued, the matter is, in fact, somebody mentioned in the VC actually. When it is the matter. So that is a creation by us without realizing the consequence.
My lord.
If he wants to resist, at least he has to deposit the money here.
But 1,35,000 I accept କରିଦେଇଛି ମୁଁ I have never
25,000 ବେସିସ୍ ଆପଣଙ୍କୁ ସେ କହୁନାହାନ୍ତି ଯେ ସେ କାହିଁ 25,000 ଦେବେନି. He is not assisting you to know to argue before the court why he will not pay 25,000 and now will pay 5,000. Please appreciate that. Unless that is there, it's a money decree, Rajneesh versus Neha. And I will issue notice without securing the decree. And they are not willing to deposit in the court. Suppose they win, the money is entirely money they get with interest.
My lord, my submission in this case is. So
No. Your submission regarding case merits I am not discussing, sir. I am discussing for issuance of notice, you are not securing the decree before the appellate court or the revisional court. Who will secure the decree before the revisional court? On what basis the court will entertain it and get the matter? Now what would happen? For these reasons, after 10 years also the case is pending there, here. They are seeking adjournment. Suppose he doesn't want to pay, let him not pay. But you have to secure the decree for issuance of notice. This court, how the court will ensure security, how the court will secure the decree? Who will pay?
my lord, that's what I'm submitting, my lord, is in the initial filing of the DV.
No, you are not getting the point. To check the challenge to RPFM or the CPC and the Rajneesh versus Neha, it says very clear that it has to be treated as a money decree. To challenge a money decree, he has to secure it. How he is securing it? He has no answer. What the court will do? And at least one matter, the Learned Counsel, he says that he doesn't want to secure the decree and he stopped arguing. Because you are not holding the brief on his behalf. You are the officer of the court. If he is not interested to take care of his own affairs, nobody can.
I'm sorry, my lord, but
No. Why you should be sorry? You should be emboldened to say. Don't be apologetic.
because I'm not talking.
If he is not coming up to secure the decree before the High Court by depositing the amount in an interest-bearing account, and it is for him. It is his choice. You are arguing for somebody's right.
Right.
Under the provisions of law, you don't have to request a court. That's a very wrong idea for me. Court is supposed to protect somebody's right, but the person is not interested to secure the decree. And there is absolutely no material that why he will not pay 25,000. That's some merits. So start with, let us say that he is entitled, he 5,000 should not have been granted.
No, the petitioner.
Sorry, 25,000 should not have been granted.
Yes.
I stand correct.
Because as per my instruction.
Because at this stage, I cannot say 25,000 is good or bad. I can issue notice, but for that, let him secure the decree.
I will obtain instruction in that regard.
Because this has resulted in a situation where every case, every transfer application, every maintenance application is involved in prolonged trial. That doesn't help him also. If he wants not to pay, then he has to get a decree that he's maybe 13 or whatever that is going on. If 13 is not pending, there can be reconciliation also.
My lord.
And the other part is that why the other side will be dragged to litigation. That is why in many cases after issuance of notice, the wives are not appearing. Rarely the husbands are seeking maintenance in 24. They can.
Yes, they can.
In some cases, there is one matter, at least I have seen here in this court also, the husband has been not granted maintenance pending right. He has challenged that.
Nice.
But largely they are not responding because they suppose they get a 125 order directing 125 initially. Then they again approach the court, get enhancement. That is 125/4 perhaps.
Yes, for them.
It is there in 125. That again is frustrated. Then they are dragged to High Court. They do not know. As such, they are not getting 25,000. So that is how they lose faith in the legal process. That is one of the major reasons that nobody is responding to court's notice, because for approaching that court, is it that it is free? They have to travel. They have to bear expenses. They should pay the lawyer's fee. As such, they are, getting an order from the court, they are unable to get anything. Further litigation, so that is how, so there is a purpose. Who has made the provision in the CPC, they have understood law. It's a legislative provision, it's not court's innovation.
No.
Appearance. It is submitted, the petitioner husband is before this court, challenging the order, the judgment and judgment and decree dated 21/10/2024, passed by the learned judge by the JMFC Rural Rourkela in criminal miscase number 112 of 2025. Seeking revision of the said order. In view of the law laid down by the Honorable Apex Court in Rajneesh versus Neha, that the amount directed to be paid to the wife in the marriage under section 125 of CRPC, into bracket, since repealed and substituted by pari materia provision contained in VNSS text. Bracket closed. Is in the nature of a money decree, and the petitioner is seeking to challenge the said decree in favor of the opposite party wife. How he will secure the decree for maintaining the appeal. The learned counsel for the petitioner submits that he will obtain instructions and matter may be adjourned. Accordingly, the matters have been listed for orders in the week commencing 2/3/2026. 2/3 ना अधिक
Out 50 other.
16 कर दिया.
Again.
So they are also wasting your time.
So the problem
You have better points to argue, better cases to argue. And just your time is spent in trying to understand what is happening, because they are not interested also.
problem is not.
If they have a case to say that there is no material on record, they have to show that no, I am not earning this much. Some evidence. That is the ultimate merit I am saying.
Petitioner से तो communication number ना था ये थे issue matter है राउरकेला बेली करके middleman था तो we don't talk to them the petitioners. That's the issue.
से कौन होची कि आपनकर आपण जेतबे एठी ट्रायल कोर्ट रे गोटे केस रे मैटर अपियर कहउचंती डिक्री हेला पिटिशनर आसीला पर आपण कहउछ ने हम अपील रे जिबा हाई कोर्ट. जस्ट गिविंग एग्जांपल, पैरेलल एग्जांपल. आपण कोन जे आपण डिक्री रे सिक्योर करन तो हाई कोर्ट जाई परिबेन कारण सेटा गोटे अप्रिय सत्य कथा. So there the problem starts. See, upon senior engaged color. Mr. KP Mr. is engaged. So he doesn't know what has happened in the trial court. So this is almost kind of escaping the client by just handing over the brief.
We just get
And this is part of I can't blame, I'm not blaming anyone. That's for that.
bow down, my lord. We just get the VNAMA and the impugned order to challenge. That's all we get.
That's true. That's true. I mean, there's nothing wrong or unusual there. That is how it becomes so complete lack of instruction. Yes, next please.
Austin.
Item 49. Lord,
Senior
Counsel Mr. Tripathi.
Orders
Orders, it has been reflected that as per SR there is no delay, my lord. But
argue करना
Lord, Mr. Tripathi
କରିବେ ନା ଆଉ ଠିକ ଅଛି କିଛି ତ ଗୋଟେ କରିବେ ଆପଣଙ୍କୁ ଯଦି ସେ he will misunderstand, I will take up the matter, then better to adjourn.
Item
ସେଟା କୋର୍ଟ ଫାଇଲ କରିଦେବେ ରେଜିଷ୍ଟ୍ରି ଫାଇଲ କରନ୍ତୁ.
item 16 as well.
16 ବି adjourn ହେବ 14 16 adjourn କରିଦିଅନ୍ତୁ ଡେଟ୍ କରିଦିଅନ୍ତୁ ଆପଣ 14 ଟା କରନ୍ତୁ ଶୁଣିବେ 14 23 ହୋଇକି ଆସିବ 16 ଟା କେବେ କହୁଛନ୍ତି କରିଦିଅନ୍ତୁ 16 ରେ your name sir.
I'm on behalf of R. Achari, Solan, on behalf of.
ମୁଁ ଆପଣ କଣ ଆରାଚାର୍ଯ୍ୟ କଣ
No, I'm appearing on behalf of
Yeah,
R.
but now
Achari. So, Parth Agrawal. In item
Parth
number 16.
Agrawal.
Yes, please.
Path always brings smiles into my face because I remember one. Yes. Anyway.
State
No, 15 ଟା ବୋଧେ adjourn ହେଇଛି
16
नहीं से 14 सागर 16 मेंशन कले आपण मार्क करनांदी से 14 सागर 16 कहलेनी ମଝିରେ 15 ଅଛି ନା ଫେରେ ଗୋଟେ 16 ଲେଖନ୍ତୁ ମିଷ୍ଟର ପାର୍ଥ ଅଗ୍ରୱାଲ ଟିକେ ବନ୍ଦ କରିବେ।
ସେଇଟା ସେକେଣ୍ଡ ଟାଇମ ଆଉ ଥରେ ଅର୍ଜୁନ ନଉଛନ୍ତି।
ସେଇଟା ଆପଣ ଯେତେବେଳେ ଆପଣ କହୁଛନ୍ତି ସେଇଠି ସେ ଆମର ଏକ୍ଜାକ୍ଟଲି ସେ ଆପଣ ଫଲୋ କରୁଛନ୍ତି। ଗୋଟେ ଥର କ୍ଲିୟର ହେଇଗଲା ପୁରା ଆଡଜଷ୍ଟ କରିଦେବେ।
ସେ ଜଣେ ଆସିଥିଲେ ଆଗ ଆଗ ଆଉ ଜଣେ ଆସିଥିଲେ।
I don't have any answer. ଥରେ ଆଡଜଷ୍ଟମେଣ୍ଟ ହେଇଗଲା ପରେ କାହିଁ ଆଡଜଷ୍ଟମେଣ୍ଟ ହଉଛି I don't have any answer.
ଆମେ ତ ଭେକେସନ ଷ୍ଟେ ପକେଇଛୁ ମାଇଲର ଭେକେସନ ଷ୍ଟେ କେତେ ଥର ଅର୍ଜୁନ ନେବେ? ଏଇଟା ଆମେ ଆଜି ଚାହୁଁଥିଲୁ କରିଦବା ପାଇଁ ଆଉ ସେ ଅଛନ୍ତି ଅନ୍ୟ କୋର୍ଟରେ ବି ଅଛନ୍ତି ସେ ଆଜ୍ଞା କେତେ ଥର ଏଇଟା ଲାଷ୍ଟ କରିଦିଅନ୍ତୁ ଆଉ ଗୋଟେ ଅର୍ଜନ କରିକି ଲାଷ୍ଟ କରିଦିଅନ୍ତୁ ମାଇନର। ସେ ତ ଜାଣିକି ନଉଛନ୍ତି ଅର୍ଜନ କେତେ କେତେ ନେବେ? ଏଇଟା ହଉଛି ଲାଷ୍ଟ ଟାଇମ ମାଇନର କରିଦିଅନ୍ତୁ। ଆଜ୍ଞା ଇତିଶ୍ରୀ ମିଶ୍ର। ସେ ଏନହାନ୍ସମେଣ୍ଟ ଏନହାନ୍ସମେଣ୍ଟ ଟାକୁ ଷ୍ଟେ ଅର୍ଡର କରିଦେଇଛନ୍ତି ସେଇ 22 ମସିହା ନାଇଁ ଆମେ ମା ପୁଅ 2 ଜଣ 4,500 ପୁଅ ପଢୁଛି MCA 4 ରେଲୱେ ୟେସ୍ ମ୍ୟାମ୍ ରେଲୱେରେ ଚାକିରି କରୁଛି ତା ପୁଅ ପାଇବ ତା ହଜବେଣ୍ଡ ୟେସ୍ ମ୍ୟାମ୍ ଲାଷ୍ଟ ଚାନ୍ସ ଦିଅନ୍ତୁ। ଏଇ ଫେବୃଆରୀ ମାସରେ ମାଇନର ରଖନ୍ତୁ ସର୍ଡେଟ୍ ମାଇନର
only party wise to the marriage side of marriage side to survive if we sold the 500 per month. Okay, it's just been enhanced to.
हमारा नाम से 8,000
It's been enhanced to an amount of 8,000 is
per month.
Railway insurance.
रेलवे एम्प्लॉय ईस्ट कोस्ट रेलवे
It's a network of resource railway.
It's 60,000 पाउंड
Concern expressed at the bar of the opposite party. The matter is answered. Yes.
internal stage interrupts.
And the answer to take it up in the week of the street. The mob thing police office. It's reluctantly answered.
Last chance one.
The next day, the reports are not extended.
Last chance one.
Last move, you essentially have you have got a better only two projects. The one extended.
Yes, nothing.
Last.
Yes,
May please your lordship. Lordship in the last date, Maybe it's on BSc.
Yes. Stay the line.
No, Lordship. Lordship? Yes, Lordship. I am in the other courts, Lordship, in that time. So, Lordship. No. Lordship.
My lord, lower court, I don't know if some other advocate, I am also not the lower court counsel. Execution, no, my lords. Enhancement, execution, no. No, sir, pending. My lord, I don't have the information regarding execution.
Lordship, I don't have any knowledge about the enhancement petition, Lordship. Yes, sir.
Absolutely, when you talk about the payment of the technical use, that's the best way.
Yes, sir.
So, CC paragraph, CC paragraph for the petitioner. The subject of the opposing party. Also for the petitioner, 6,000 adjournment, also for the opposing party. Objection to the same. Or objection at all by the last part of the truth, this was very clear. That investment stage, there is a part, see part actually in the showing. Effectively, my order. Enhancement,
enhancement, sir, hey, enhancement recently filed. Enhancement order, hey, this order, the order still remains 8,000, 7,000, 7,000 rupees.
7,000.
My lords?
Sorry, actually my microphone is switched off. That amount is not being paid.
No.
Lordship, yes, so I am coming to that point. Lordship, I am already paid 2,30,000.
Already no. You kete dechandi kete. Already paid to seda ila paisa.
Yes, Lordship, I am coming to that point. Lordship, 5,95,000 due ଅଛି.
କେବେ କୋଉଠି order ଦେଖିନି? ବାକି ପଇସା ଦେଇ ଦିଅନ୍ତୁ ନହେଲେ ଆକୁ ପର୍ସୁ କରନ୍ତୁନି.
Lordship, I am not.
Sir, if I follow Supreme Court,
No, Lordship, I
have to follow Supreme Court direction. You can't say no.
No.
If I
Yes.
that the London Council responds that, have you marked the Supreme Court order on this?
No, Your Lordship.
For execution of decree, this court has power for arrest and detention.
Lordship,
You must understand. Unless
Lordship,
you
I am not pay the amount, Lordship.
this is not a debate competition. This is interaction with the court.
Yes, sir.
Don't go and say lordship, and don't allow the court to say anything.
Yes, sir.
If I'm saying something, then you have to say straight away on my face. No, that's not the law. That's not the decision. So unless you tell these coercive measures to be taken by the court, or there is a provision in 125, 125(3) is a provision, or 4 is a provision.
Or for maybe 4 years, 1 year.
Whatever.
Provided Lordship. No.
ଯଦି ଆପଣ 4 କହିଲେ ସେଇଥିପାଇଁ ଆପଣ ସେ ମାନୁନାହାନ୍ତି.
No, sir.
ଆପଣ ଯଦି ମୁଁ ଅଧିକା ଜାଣିବି କେମିତି ହବ କେସ୍ ଆପଣଙ୍କର.
Yes, sir.
So you have to tell these things to your client. Last time ବି ଆପଣଙ୍କୁ ବୁଝା ହେଇଥିଲା. So you will be arrested and detained.
Lordship, the marriage is already dissolved, Lordship. I am not
Sir, dissolution of marriage is not a constitution.
ready to pay a permanent alimony.
Sir, don't give a speech on that. It is not a debate competition. ଆପଣ ମାନେ କଣ ଜାଣିଛନ୍ତି କୁହନ୍ତୁ ମ୍ୟାରେଜ ବିଷୟରେ? ଆପଣ 125(3) ର ଲାଇବିଲିଟି ଟା ମ୍ୟାରେଜ ଡିସଲ୍ୟୁସନ ପରେ ରହିବନି ବୋଲି କିଛି ନାହିଁ ସେଠି ଲ.
But Lordship,
ଆପଣ ଯଦି ଏରି ନାହିଁ will be arrested.
but till now they are not filed the execution, Lordship.
No, ଆପଣ ତାପରେ କହିବେ ଗୃହ ପ୍ରସାଦ ଦେବାକୁ ପଡିବ. Sir, କୋର୍ଟ ଗୃହ ପ୍ରସାଦ ଦିଏନି. କୋର୍ଟ ଆରେଷ୍ଟ କରିକି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଗେଷ୍ଟ କରେ ସେ ରହିବେ ଆପଣଙ୍କର ମିଷ୍ଟର ମହାନ୍ତି ଆଉ ମିଷ୍ଟର ସେଠୀଙ୍କ ଗେଷ୍ଟ ହେଇକି ରହିବେ. The learned counsel for the petitioner seeks adjournment. He doesn't have any instruction regarding the amount that has been paid. The exact instruction regarding the amount paid. ଆପଣ କୋଉଟା ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି? ଆପଣଙ୍କୁ ଯେତେବେଳେ ଆସିକି when somebody approaches you and tells you that I will not pay, you must have the courage not to accept the brief.
Yes, Lordship, I am.
You deposit it here.
Yes,
You deposit it here by the next date. The entire amount you deposit or will be arrested.
Lordship, I am already deposit 2,08,000 rupees.
Here you have deposited.
No, Lordship.
The entire area dues have to be deposited here.
Lordship.
अरे लॉटशिप डिपॉजिट कर परिबेन
No, Lordship. I may be pardon your Lordship, but I am ready.
ଦେଇଛନ୍ତି ଟୋଟାଲ
ମୁଁ 2,31,000 ଦେଇଛି ଆଉ
ତାପରେ କରନ୍ତୁ allow the ଆପଣ don't ଆପଣ ଗୋଟେ ଆପଣଙ୍କର you are unable to control your speech also total due ଆପଣଙ୍କର କୋଉ ଜଜମେଣ୍ଟ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଜାଣିଛନ୍ତି ନା ସେଟା ବି ଜାଣିନାହାନ୍ତି
Yes, Lordship, I know that.
କୋଉ ପେଜ
Page, your Lordship. Annex number 1.
page your lordship
Page number
27
Page number 13, Lordship.
27
Order ଟା ସେଟା ଅଛି annex ଟା ଦେଇକି
ଆପଣ ସିଧା ସେଠି ଯାଆନ୍ତୁ 7/12/18 ରୁ ଆଜି କେତେ ହେଲା 7/12/25 7 ବର୍ଷ ତାପରେ ହଉଛି 1/12/2/12 7 years 2 months that comes to 86 months $7,000
6,02,000.
ଯେହେତୁ ଆପଣଙ୍କୁ ମୁଁ ମଲ୍ଟିପ୍ଲିକେସନ ଟା କହିଦେଲି ଆପଣ ସେଟା ମତେ କହିବା କଥା
No, my lords, I have already written it on my.
କାହିଁକି total amount of 6,02,000 is due to be paid by the petitioner at the rate of rupees 3,000 per month to the petitioner number 1 who is the before the learned trial court and 4,000 to the petitioner number 2 from the date of application that is 7/12/2018. The order has been violated with impunity. The Superintendent of Police shall ensure presence of the petitioner before this court. On the next date of appearance,
I may
on
pardon
the
your
state
Lordship.
date, the petitioner shall make the payment of the dues, the amount of rupees 3,70,000 as due till date.
I may be pardon your Lordship. Lordship, 4,60,000.
At this stage, the Lord Counsel for the petitioner submits that he may be pardoned. Regarding non-compliance of the court's decree, there is no scope for this court to grant any pardon. Yes, what next?
Lordship, in the last order, Lordship directed the.
Sir, your smiling face is also
No,
not
no, no, your Lordship, I apologize for that. Real.
No,
But,
I'm really excited. I'm really happy that to see you smiling a lot for non-compliance with the order. Yes, what next?
Lordship, my humble request before your Lordship is to. Lordship, that petition is ready to pay the amount, Lordship, but the marriage is dissolved.
The petitioner it is submitted that
But
the petitioner is ready to pay, the marriage is dissolved.
Lordship,
In considered opinion of this court,
Pharmacy is ready to pay the permanent every money,
commissions
Lordship.
are irrelevant as far as payment of amount of maintenance is concerned. You married how many petitioners you married?
Lordship, no,
How many persons?
Lordship,
Have you read the order? What you are submitting, sir?
Lordship, that
Please come to your senses. You are in
the
open.
maintenance. No, Lordship.
କହୁଛନ୍ତି divorce କଥା କାଇଁ କହୁଛନ୍ତି?
Lordship, ମୁଁ ready ଅଛି, Lordship, ready ଅଛି, permanent.
Sir, that point is taken and already recorded. Payment of 125 is not whether you are married to petitioner 1 or 2, that's not yes. What next? Any other submission?
Lordship, that
It's hopeless, sir. You are saying that you have got divorce from your daughter.
no, Lordship, I am not go to the opposite part number 2, Lordship.
So then you should have measured and guarded in your statement before the court.
Lordship,
For non-payment of then you will say the same thing for suppose you are now 125 is a provision for all, mother, father, child, illegitimate child.
Yes, Lordship. I
So
know.
please understand what you are saying in the court. Then what next? So that point is taken care of. What
I
next?
am ready to pay a permanent alimony, Lordship.
Sir, you pay. The learned counsel for the petitioner submits that he is ready to pay permanent alimony.
But before that, we have to.
Which has nothing to do with the present proceeding. As the present petition is not under section 25 of the Hindu Marriage Act, and it is under the section 125 of CRPC. Yes, permanent alimony will pay. Then what next?
No, Lordship. I am ready to.
Yes.
No, Lordship.
So when he will appear, you will ensure his presence or he will be arrested.
Lordship, I am ready to appear, Lordship. And
No, are you listening or you are English बुझुଛନ୍ତି ନା ଅନ୍ୟ କୋଉ language
no,
ବୁଝୁଛନ୍ତି?
Lordship.
ସେ କେବେ appear କରିବେ?
Lordship, I have to take instruction, Lordship.
The learned counsel for the petitioner, on being asked whether the petitioner will appear in person on the same date, he submits that he will obtain instruction. The petitioner shall be produced before this court on 16/2/2026.
16.
The matter shall be 16/3/2026.
Lordship.
Mark that 2 p.m.
Lordship.
The order shall be communicated to the Superintendent of
The
Police.
petition was a soldier and he is working in our secretariat, Lordship. So she may be. No.
So what is, give the details of, if you want to escape arrest, give the details of his employment.
Lordship. Yes, Lordship. Lordship. I am fine, Lordship. Can be appear.
So his employer will also be produced on that date.
Lordship.
Give the details, his employer will also be produced so that he can deduct the money. Where is employer?
Maybe in secretariat.
The learned counsel for the petitioner, on being asked, the advantage is that this is recorded and this is live. The learned counsel for the petitioner, on being asked where the petitioner is employed, he says that maybe in secretariat,
Maybe in secretariat. I don't have.
maybe in secretariat, co-secretariat, my secretariat or which secretariat?
Lordship, I don't have the knowledge proper.
अरे secretariat कोठी?
Bhubaneswar. Bhubaneswar.
Odisha State Secretary?
Yes, yes.
State Secretary
Yes.
Bhubaneswar. What is his name?
Sudhir Anand.
What is this Commander MSO office in charge?
Lordship, she Indian Navy work actually. She was
The-
no Lordship. But now he is a director.
The copy of this order shall be handed over to the learned DSGI, Senior Advocate CPK Padi, with the address statement as mentioned in paragraph page 13 of the petition, to locate the employer of the petitioner who was the opposite party before the learned trial court. Yes, what is the decree of divorce? What is the amount due in alimony?
Decree of divorce is alimony mentioned here, Lordship.
Yes,
Lordship, it was past
on being asked,
Expired order.
the learned counsel for the petitioner doesn't have any, since the learned counsel for the petitioner has referred to a decree of divorce where the petitioner wants to pay alimony. Again, he fails to answer
Lordship,
the date of decree of divorce, the details of the
Date.
decree granted, and the nature of the decree, whether any permanent alimony has been granted or not.
Lordship, permanent alimony was not there, Lordship. That
Then you should not have. You should not have. Don't play with fire by instance of a ordinary litigant. Please don't. Always avoid to play with fire like you advise children. You must understand that you are being watched. It is recorded. Your entire statements and performance, everything is on record. The statements made at the bar during these proceedings shall be kept on record as has been recorded during the court proceeding, so that for further adjudication, the said recording can be referred to. Registry to do the needful, to serve the copy on the copy of the order on the learned DSGI to enable him to locate the petitioner. The matter shall be listed on listed to be mentioned on 2 March 2024. Yes. The court will find him out.
I may be late for.
So Bhojra said for the petitioner, Mr. Mohanty. Your name, sir?
इसके साहू.
So S.K. Sahoo for the opposite party, the law and counsel for the petitioner submits that. At item 20, Bhojra said, Mr. S.K. Sahoo. The law and counsel for the petitioner submits that he has received copy of the counter filed by the opposite party and maybe granted time to go through the counter and file response of the petitioner if so advised. How much time, Mr. Seth? How much time?
Maybe 1 minute.
As prayed for, the matters shall be listed in the week commencing 13. Tiristil. Okay. Yes, next please.
In the meantime, entry order maybe.
Entry order as passed earlier shall continue till the next date of hearing.
How much?
Yes.
41.
Yes.
Praying for an adjournment.
Simply date कर दियो तो चले.
Lots of 2 weeks later.
So date कर दियो.
The interim order is to be continued.
Interim order as passed earlier shall continue. अच्छा अपन होचंती अपन ना से
Your Lordship.
अपन को नाटा
Sumanta Bhuya, Your Lordship.
Mr. Sumanto Bhuya for the petitioner. Opposite party के आप ये रिपोर्ट तो करना है.
No, Your Lordship.
Opposite party blank. None appears for the opposite party when the matter is called. The matter stands adjourned. To be taken up in the week commencing 23-2026. Interim order as passed earlier shall continue till the next date of hearing.
Deeply.
Yes, please next.
32.
May it please your lordship. My Lawrence Senior is on undergoing
Simply adjourn कर दिया.
paper next week.
Next week करिए बोले सर.
We come
जल्दी अपन को adjust करिए पड़ेगा. 14 week.
Obliged.
33.
Yes, Mrs. Bastia.
My lord, I pray for that if the matter will be go to the mediation, my lord.
Mediation regarding what?
Then my lord,
Who will pay the amount?
my lord, the petitioner is at the age of 63. And
So that is more the reason that he should pay. He should not have this material thirst for material gains and running around in circles. Because you have to assist me that what mediation I can advise in a case of payment.
payment.
You will pay or Mr. Nath will pay. You agree? Then I will pass. But don't include me.
Both are residing in.
No, 2024, the order still today they are not paid a single by the
The mediation होगा अपन देबे.
mediation if you have paid.
अपन देबे.
Both are residing.
Actually, you are not. ते अपन देबे बोली mediation है क्या अपन देबे. Citri mediation here mediation is a tactic for adjourning and delaying the matter.
Yes, sir.
That's the problem. You must understand.
My lord,
As far as payment is concerned, what mediation can happen?
Yes.
my lord, fact is, my lord, both husband, wife and residing are in one building, my lord. Wife residing in the ground floor.
One building disentitles the wife. I will be happy to pass that judgment. So that's a new concept. If the husband and wife are residing in the same building, the wife is not entitled for maintenance or food or clothing, anything medical help.
Residing in the ground floor and.
So you must understand that the law has not developed like that. 125 law has not developed like that. Rather, more and more provisions are added. Domestic violence, financial assistance. Why it is added? Because 125 was thought to be inadequate in certain cases.
My lord, your
So here you pay and then you go for mediation or whatever.
husband is paying all the electric bill, water bill, medicine expenses, all
I'm made to see a person who survives by water bill and electric bill.
medicines, food.
You must
expenses.
understand. You must understand, Miss Bastia. This is a matter of evidence. When I cannot survive by electric bill and water bill paid by because I stay in bungalow, so my 90,000 is deducted. I can't survive. Still, I have to spend for my food and other things. I'll pass an order that since the electric bill is paid, so she is not entitled for any maintenance. And many times the matters are re-argued. Our revision, you should go through the decisions of this apex court. To what extent in a revision application the court can, the law is that even if I form a different opinion, I cannot substitute. You must understand that. If it is based on the evidence, material on record, that is enough. Adjournment simply नहीं जानते.
My lord, he is pension holder, my lord. And he is paying for 35,000 year.
ଆପଣ ଏକ୍ଜିକ୍ୟୁସନ କାହିଁ କରିନାହାନ୍ତି? ପେନସନରେ ଆପଣ ସେଠି ଆମାଉଣ୍ଟ ତ ପାଇ ଯାଆନ୍ତେ. ଆପଣ ଏକ୍ଜିକ୍ୟୁସନ କରିବେନି. କୋର୍ଟରେ ଏଠି ମ୍ୟାଟର ପେଣ୍ଡିଂ ରହିବ, ସେଠି ବି ପେଣ୍ଡିଂ ରହିବ. That adds to pendency. At least execute heଲେ you will think further or you will think further.
I also said to my client to start
You
executing.
must understand that what is happening.
Yes, my lord.
Yes, when do you want?
Arjun.
Mrs. P. Bastia for the petitioner, Mr. Amit Nath, A.K. Nath for the opposite party. The Learned Counsel for the petitioner submits that the matter be sent for mediation. So, in response, on being asked, when the amount due is not paid by the petitioner, which is in the nature of a money decree, what mediation can achieve? The Learned Counsel has no further answer. Stop. Para, it is submitted by Mr. Nath, the Learned Counsel, Mr. Nath, Learned Counsel for the opposite party that kete area रहलानी?
2024, my lord. No, 2024. The 30/4/2024 up to 2024, my lord.
इससे पहले है 8/24 8/32 34 मासु केते
9,000.
डेट आउथरे कहिबे
30/4/2024.
The amount payable to the petitioner as opposite party as maintenance is due since 30/4/2024. The petitioner is a pension holder. So, if the entire period till date is counted, the amount is due for 34 months till February 2026. The amount coming to 3,06,000. 3,0,6,3 Stop. It is interim order kichhi nahi. So then you have helped him. So you should help him also.
Yes, my lord.
Then why you are not reconciling? You are not executing. You are just keeping the matter pending. At this age, you should also cooperate there.
Yes, sir.
As prayed for by the Learned Counsel for the petitioner to grant further opportunity to the petitioner, list in the week commencing 30/3/2024.
24.
So Pranab Ranjan Chatterjee for the petitioner, Mr. Ajit Chandra Mahapatra for the opposite party. Because mediation fail hai. Thanks that your case is listed after the other matter. It's only time spent in for nothing. And the mediation is overburdened because they can't they have to persuade people. If 40 cases are taken up, how many they can give time? So now what is the solution to go ahead? What is your instruction? What are your instructions, both of you?
I'm not interested to keep the petitioner as That's why
ଆପଣଙ୍କର ଏଇଥିରେ କାହିଁ ସେଟା କରୁଥିଲେ ଆପଣ ତ ସେଠି ମେଡିଏସନ ହେଇଥାନ୍ତା MATA ରେ କି CP ରେ
ସେଟା
TRPC ରେ 24 ରେ କଣ ମେଡିଏସନ ହେଇପାରିବ
କୋର୍ଟ ପଠେଇଥିଲେ
ହେଲା ଯେ ସାର୍
ହେଲାନି
sir we are expecting better results but nothing is happening only the matter gets dragged actually appearance likely the mediation report dated so and so has been furnished indicating that the mediation has failed. The indicating that mediation became within quote unsuccessful quote ends. Hala? The matter shall be listed for admission in the week commencing 6/4/2024. Yes.
I have filed divorce proceeding at Jagatsinghpur. Now, after filing of the divorce
Secretary
proceeding,
counseling hetle better in that. In a transfer petition. What is the scope of this court to interfere also?
what I have to submit is that
Can be done. There is a scope for mediation there.
yes,
Yes.
what I have to submit is that now wife filed a maintenance petition at Bhubaneswar and seeks transfer of CP to Jagatsinghpur at Bhubaneswar. Now both parties are not willing to pulling on well. Both the matter may be tagged and transferred to one so that the matter can be.
GR case ଅଛି
GR case FIR କଣ ଭୁବନେଶ୍ୱର ସେଟା jurisdiction ଆସିଗଲା ଭୁବନେଶ୍ୱରରେ ଆପଣ ବୁଝିବା ଦରକାର ଯେ
After
we are adding to the burden. Bhubaneswar is overburden. And your case is initiated CP in the year
2020,
23,
25.
25. Now it will come to the list of 26 matter. On transfer, the original cannot be maintained. So how does it help both the parties?
Interim maintenance petition has been filed 2026 recently at Bhubaneswar. Now say wife
ସେ ଆପଣଙ୍କ କେସଟା ଟ୍ରାନ୍ସଫର ହେବାକୁ ଚାହୁଁଛି ଭୁବନେଶ୍ୱରକୁ ଆପଣ ଚାହୁଁଛନ୍ତି
ନା wife
ସିଏ ଚାହୁଁଛନ୍ତି ଆପଣ ରାଜି ଅଛନ୍ତି ତ
वो जेहेतु वन सिटी ହେଇଗଲାଣି ଆଉ CP
I understand. Dispose କରିଦେଲେ at least that's a correct approach. You pursue the main case instead of keeping the matter TRPC pending here and go mediation. ସେଠି ତ mediation ହବା କଥା ନା memo ଦେଇ ଦିଅନ୍ତୁ joint memo sign କରି ଦେଇ ଦିଅନ୍ତୁ disposed of. Yes.
ट्रांसफर ସେଠି
ଆପଣ ସେଇ ଫ୍ୟାକ୍ଟ ଗୁଡାକ ଖାଲି ସେଠି କେସ୍ ଡିଟେଲ ଗୁଡାକ ଲେଖି ଦିଅନ୍ତୁ I will see that I will find out also. I usually check. But ଆପଣ but both of you sign.
yes
That ଏଇ cases pending ଅଛି ଏଇ ଜାଗାରେ ଏଠି ଖାଲି ଲେଖନ୍ତୁ
ଆଜ୍ଞା
and you can refer that after the failure of mediation the matter may be closed at the TRPC may be closed. That reason you can also write because you have also made an effort. They are not listening. Or maybe you're instructing counsel from the lower court, they are not listening.
It is my submission. So far as
not concession. I am not recording. I will try to diligently reproduce whatever is the contention.
mine.
It is not that you consider that let it be transferred. But obviously, Bhubaneswar, it will take a lot of time.
Yes.
It is piling up. କଟକରେ ରାଜି ହଉନାହାନ୍ତି କଟକ has a better chance.
କଟକ ହେଲେ ସରିଯାଆନ୍ତା ଶୀଘ୍ର ଦିଟା ଯାକ କଟକ ପଳେଇ ଆସି ଭଲ
ସବୁଗୁଡାକ କଟକରେ କରନ୍ତୁ କଟକରେ ପେଣ୍ଡେନ୍ସି ବହୁତ ଅଛି କିନ୍ତୁ
ଦିଟା ଫ୍ୟାମିଲି କୋର୍ଟ ତ ସାର୍ ସେଠି
ସେଠି ଦିଟା ଫ୍ୟାମିଲି କୋର୍ଟ ଆପଣ କେତେଟା କେସ୍ ଦେଖିଛନ୍ତି
ସାର୍ ଦିଟା ହେଇଛି
ଭୁବନେଶ୍ୱର enormity ମାନେ one cannot imagine. In revenue side I have marked that what is the amount of cases in Bhubaneswar in revenue matters because I had a very close interaction watching the cases. So family is the same thing and most of the marriages are happening in Bhubaneswar throughout India, Orissa.
but my learning
Now it's all in the pan-India destination. So jurisdiction where the marriage was solemnized. ଆପଣ ଦେଖନ୍ତୁ ଯଦି କଟକ ଦେବେ ଦେଇଦେବେ ମୋର କିଛି
ଆର୍ଜନ ହେଇକି ରହୁ ମାଲର ସେ ଆସିଲା ପରେ ସେ 30 ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣି ତାପରେ ସେ ଜିଆର କେସ୍ ବି ସେ
30 ତାରିଖ ରଖନ୍ତୁନି ଯେତେବେଳେ ସେ ଆପଣ ଗୋଟେ ଆପଣଙ୍କ ପ୍ରେୟାର ଯେହେତୁ ସେ ଇଏ କରୁଛନ୍ତି ଆପଣ ସେ ରାଜି ହେବେନି ତାଙ୍କ କ୍ଲାଏଣ୍ଟ ତାପରେ ରାଜି ହେବେନି ଏଗେନ୍ ଆଉ ଶୁଣନ୍ତୁ TRPC ରେ ଆପଣ ଅଲରେଡି ବର୍ଷେ ଖର୍ଚ୍ଚ ପାଇଲେଣି ସେଇଠି ଯଦି କରିଥାନ୍ତେ କିଛି ହେଇଥାନ୍ତା ତା ଭିତରେ।
ସାର୍ ସେ ଭୁବନେଶ୍ୱର ରହୁଛନ୍ତି ସେଇଠିକି ପଳଉ ସବୁଠୁ ବେଟର ସେଠିକି ଆସିବୁ।
ଶୁଣନ୍ତୁ ମୋ ଜୀବନ ବୋଲି it is only a solution that maybe both of you can assist the court here. Both of you. So ঠিক আছে ଭୁବନେଶ୍ୱର ଯିବ ଆପଣ ଦେଇ ଦିଅନ୍ତୁ ଭୁବନେଶ୍ୱର ଯିବ ଠିକ ଅଛି। Yes,
Sorry, my lord, the quantity calculation ଟା wrongly ହେଇଗଲା ଏଟା 2 lakhs ହବା କଥା 3 lakhs 9,000 କରିଦେଇଛନ୍ତି।
ଡେଟ୍
30/4/2024
30/4/2024
into 9
ନାଇଁ ଆପଣଙ୍କର ସେ କେସଟା ଦେଖନ୍ତୁ ଆପଣଙ୍କ ଉପରେ କଣ ପୁରା ବି I have to check the date then again. RPFM ରେ ଅର୍ଡରଟା କଣ ହେଇଛି ଦେଖନ୍ତୁ ଅର୍ଡରଟା ପେଜ ଦେଖନ୍ତୁ କୋଉ ପେଜରେ ଅଛି
page 50
50
ହଁ
ମତେ 15 ଶୁଭିଲା 15 ଶୁଭିଲା। ତିରିଶ 4/24 ରୁ ଆପଣଙ୍କର 30/4/26 ରେ ହଉଛି 24 ମାସ
2 ମାସ କଟିଯିବ
2 ମାସ କଟିଯିବ 22 ମାସ 9,000 କୁ 22 ରେ ଗୁଣିବାକୁ ପଡିବ
1,98,000
1 lakh. Thank you. Yes, next.
27
You have to bring for adjournment.
They are not informing.
yes
Every day same thing is happening. That when I have been requesting, please inform the other side. ଆପଣଙ୍କ ନାଁଟା
Shubham Ghosh.
power name. So Suman Ghosh on behalf of MS Saulabala Jena for the petitioner, Ms. Dipali Mahapatra for the opposite party. Adjournment is sought for on behalf of the petitioner. Sorry. The matter shall be stayed in the week commencing 30/3/2024. They should. Yesterday there was a lot of difficulty in this that they are not intimating. Today at the mentioning stage, someone objected that went in for 10 minutes. You should have, especially in after notice hearing matters. Because it cannot proceed in absence of one side. Upon the full fledged hearing karibe, other side kon karibe. Please appreciate that. Please make it a point. Yes.
28
my lord, they have served us a copy, my lord, a copy of the instruction they have got. Learned fail was there.
Counter ଗୋଟେ ଦବାର ଥିଲା ବୋଧେ ଏଥିରେ
ନାଇଁ ସେଥିରେ amendment ପାଇଁ ଫାଇଲ କରିବାର ଥିଲା amount.
ସିମ୍ପଲି ଆର୍ଜନ କରି ଦିଅନ୍ତୁ ତାହେଲେ
2 ଦିନ ଅର୍ଜେଣ୍ଟ ଅଛି ତେଣୁ କାଲି କି ନହେଲେ ପରଦିନ ରଖିଲେ ଟିକେ
ନାଇଁ କାଲି this bench is not available tomorrow and day after. So Mr. J. Barik,
MR Pradhan, my lord.
Mr. MR Pradhan for the petitioner, Mr. Anshuman Sethi for the OP number 1, Mr. Palta Singh, S. Palata Singh.
IMO फाइल करथिले फॉर अमेंडमेंट सेटा
कॉपी सर्व कर दियंतु आगो
कॉपी सर्व कर देछि ऑलरेडी कॉपी सर्व
जहाँ लास्ट ऑर्डर जहाँ थिला सेटा ठीक है एसपी मिस्टर सीनियर एडवोकेट अलॉन्ग विद मिस्टर पाल्टा सिंह 2 and 4, मिस्टर अंशुमान सेठी 1 and 3.
मैंने एटा बले हमर जो तांको एंगेज करियर अछि जे किंतु अंडर सच टर्म्स एंड कंडीशन सेटा उठे देइथिल तांको
एफिडेविट को दे दियो
एफिडेविट
बेटर होची यू शुड मेक द रीडिंग्स अपडेटेड because now he starts denying or disputing that it is not part of the record. Then the court, when you are neither here nor there, pursue it, but complete the entire thing. Upon file karibe readings ko, though strictly speaking, you have to take leave of the court. Here everything is, I mean, you should take leave of the court to file anything. After you file it, serve copy. Let him respond to that. ଆପଣ ସେଟା ସିମ୍ପଲି ଗୋଟେ affidavit ରେ କରିଦିଅନ୍ତୁ ଫାଇଲ।
Yes, ma'am.
ଆପଣ instruction ଦେଇଛନ୍ତି ଠିକ ଅଛି। You seek instruction also on that.
My lord, then my lord, on
But
Monday,
I'm not recording those things.
No.
I'm simply adjourning it.
on Monday may be required.
ମଣ୍ଡେ କରିବନି ଏଟା ଆସିବ ୱିକ୍ କମେନ୍ସିଂ ଆଜି ହଉଛି କେତେ 18 ତ ସେ 2 ୱିକ୍ ରେ ଆସିବ
Monday,
ୱିକ୍ କମେନ୍ସିଂ 2-3 ମଣ୍ଡେ ମାନେ ଆପଣ 23 କହୁଛନ୍ତି।
ହଁ 23 ତାରିଖ କିମ୍ବା 24 ତାରିଖ
23 ରେ କେତେ ମ୍ୟାଟର ରଖିଛନ୍ତି? 81ଟା।
23 କିମ୍ବା 24 ରେ ଆସିଲେ ବି ମୁଁ ତା ଭିତରେ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ବି ନେଇଯାଇଥିବି କାରଣ ସରି ଯାଉଛି my lord,
ଗୋଟେ ଦିନ ନ ହେଇପାରେ।
ଆକ୍ଚୁଆଲି ତାଙ୍କର
ଆପଣ 23, 24, 25 ଯୋଉଟା 26, 27 ଯୋଉ ଦିନ ହେଲେ ବି ହବ।
ସେଇ ସପ୍ତାହରେ ଯେକୌଣସି ଡେଟ୍ ଗୋଟେ
25 ଛାଡି ଯୋଉ ଦିନ ହେଲେ ରଖିଥିବେ। 25 ଟାକୁ ଆଭଏଡ କରନ୍ତୁ। ପଛେ ଆପଣ ଡିଷ୍ଟ୍ରିବ୍ୟୁଟ କରିନଥିବେ କଲିକୁ। ଠିକ ଅଛି। List of the week commencing 23. Yes, next.
49.
Yes, Mr. Ashok Kumar Behra for the petitioner. Admission notice sufficient. Yes. Kiran Raut for the opposite party.
Yes, my lord. Opposite party number 1 and 2, I filed contact the opposite party number 1 and 2. They are staying at the village, and yesterday afternoon I filed the wakalatnama, and
It has come. So what is the matter, sir? It requires hearing.
In person. Yes, it
So you take a date. Because it will not be possible.
In pursuance to the order dated 15/1/26 passed by your lordship.
Yes.
The husband has already deposited 2.5 lakhs in the court of Learned Judge Family Court Karta without prejudice.
Correct.
And also filed the petition for recalling of expertise husband.
Madam, that amount is partly secured. 2.5 lakhs has been secured.
Yes,
Madam, of this court. So let it come on another day because we will not be able to complete hearing. Have some engagement. So
yes, my lord, because I am the opposite party numbers 2 is a student and he is in class 6-7. So within the weekdays she cannot come. So she will come on the Saturday or Sunday.
personal affairs to kichhi nahi. Upon instruction niyantu.
Yes, I have taken personal.
Mr. Behra is saying that whatever conditions imposed by the court for issuance of notice has been. Are Mr. Barik upon to samne re chida hai. Upon dekhu bhi na. No, best thing is that upon eputu asle seputu pole asle upon seputu asle seputu polochun.
Yes, ma'am.
So ଆପଣ ଯଦି କିଛି objection ଆପଣ ଯଦି କିଛି ମାନେ instruction ଅଛି ସେ comply କରିନାହାନ୍ତି ତାହେଲେ ଠିକ ଅଛି।
ନା ସେ ତ comply
କରିଛନ୍ତି as it seems। ଗୋଟେ date ନିଅନ୍ତୁ ଆପଣ। It is submitted by the learned counsel for the petitioner that he has complied with the conditions as directed by order dated 15/1/2026। The matter is listed for admission hearing. List in the week commencing 23/3/2026। 30
We commencing 30.
30
ମାର୍ଚ୍ଚ ମାସରେ ବାହାରେ ସବୁ ଅଛି।
ତା ପରଟା ହଉଛି
Second.
6/4
Internal.
1 2 3 6/4 interim order as passed earlier shall continue till the next date। upon instruction niyantu।
Yes, no. Say copy of the money receipt or deposition that may kindly copy.
ଆପଣ ଦେଇଦେବେ
ଏଇ ସାଙ୍ଗେ ସାଙ୍ଗେ ଅଛି କି ନା ଜେରକ୍ସ କରି ଦେବେ?
Xerox କରି-
ଟୁଡେ ଓନ୍ଲି। ଅବ୍ଲେଶ।
ସେଠି ଅର୍ଡର କଲେ ସେଠି କୋର୍ଟରେ ଅର୍ଡର କଲେ ଆମେ
ହଁ ସେ ଡିପୋଜିଟ୍ ହେଇଯାଇଛି।
ଆପଣ 30 ଟା
ସେଟା ଆଜି ଦେବେ।
30 ଟା କଣ ହେଲା? 30 ଟା ଆପଣ ଡେଟ୍ କରିଦିଅନ୍ତୁ। sir କୁହନ୍ତୁ 30 item 30।
Item 30, my lord, I am there on VC, my lord. In fact, your lordship may kindly permit me, I can take a short adjournment so that I can verify the LCR and I can assist the honorable court. In fact, I have the copies.
Definitely, because of consent of time, I'll be more than happy to take adjournment from you. Yes.
We commencing 6.
My lord, 6th March.
Mr. Satyashindu Kashyap for the appellant.
Aye, my lord.
You are appearing for?
Respondent number 1.
You are Mr. Panigrahi.
Panigrahi.
Mr. K.K. Panigrahi. Panigrahi for R1. Mr. Anshuman Sethi for special LAO na kon thibo seta party thibe apun.
Land acquisition officer.
Land acquisition officer. He is LAO. So Anshuman Sethi AC for OP2. The matter is listed for admission hearing. Stands adjourned to the week commencing.
6-4.
6-4 Mr. Kashyap.
Obligement.
Yes. Password ଟା ଡାକନ୍ତୁ author. ଏଟା କେତେ number? ଜଏଣ୍ଟ ମେମୋ ସେଟା ତ ପାସଓଭର ହେଇଥିଲା ନା ଆପଣ ଭୁଲିଗଲେ ନମ୍ବର ଭୁଲିଗଲେ 24 ଆପଣ ଯୋଉ ଆଗରୁ ଫାଇଲ ବଢଉଥିଲେ ବର୍ତ୍ତମାନ ସେଇଟା ହଉଛି ସେଇ ନମ୍ବରଟା କହିବେ ଆପଣ ଆଉ 24 ଫାଇଲ ବଢଉଥିଲେ ଏବେ ସେ ସିଷ୍ଟମ ନାହିଁ 24 ମିଷ୍ଟର ଆପେରାନ୍ସ ଡାକ୍ତରୀ ପ୍ରଣବ ରଞ୍ଜନ ଛାଟୋଇ ଅଜିତ ଚନ୍ଦ୍ର ମହାପାତ୍ର ପଢିଲେ କି ଆଚ୍ଛା ଠିକ ଅଛି ଆଉ କଣ କରିବା ସେ ବୁଝି ନଥିବେ ବୋଧେ The memo signed by Agata Prabodhe Lekhichon. Orata Prabodhe is mediation report failure or successful. A key lecture. Upon lecture, tap or lecture. A memo is filed signed by both the learned counsel for the petitioner as well as the learned counsel for the opposite party, which states thus. In view of the fact that the mediation has become unsuccessful, the TRPC is kept pending here since date pet pagurali.
25/7/25 file.
25/7/25 filing since 25/7/25 and has not achieved any result. It is directed that the so and so petition pending before the Lord Judge Family Court, Court Jagat Singhpur, shall be transferred to the Court of the Lord Judge Family Court. One na two court one Family Court 1, where the other applications filed by the opposite party are pending.
Filed by the petition.
Filed by the petitioner are pending. Acha, so see Paul Lapon or you are for the petitioner. Petitioner wife in the marriage. Hello. That about it now. Number dekhidewe. Order application so and so lekhidewe. Hello. Ta pore lekhidewe. The petition stands disposed of with the above observations. Copy of this order shall be forwarded to the Lord Judge Family Court, Jagat Singhpur, ଆଉ ଗୋଟେ ହଉଛନ୍ତି Family Court ଭୁବନେଶ୍ୱର। କିଛି ନାହିଁ। Thank you.